Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law with attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level personalized representation and hands-on approach to every case. I'm Shameika Rhymes, and today we're talking about what happens when police say they just want to talk. Hi, Dylan.
Hi there.
Well, Dylan, when law enforcement reaches out and they say they just want to talk, what is typically happening behind the scenes at that point in an investigation?
Well, that can take on a lot of different molds, operations, however you want to characterize it within an investigation. But typically speaking, 99.9% of the time, there's some sort of investigation going on. And if law enforcement is reaching out to you to want to talk, they either think that you are some sort of important witness, could be, you may not be, but you could be, or you might be a person of interest or a target of their investigation. And oftentimes when they just want to talk, um, yeah, they want to talk, but it's in a effort to gain information, and you don't necessarily know what they've already discovered or what they haven't. So, that can take on kind of a loaded context, if you will.
I know when I watch all these crime shows on TV and they, knock at the door or they call and, they tend to try to make it seem like they're just trying to be your friend. But how are these conversations usually framed in a way in real life that makes them feel informal, even when they are part of a structured investigation?
That's not too far from the truth. I mean, that's a
Oh, okay.
tactic. I have to say that it's a way to get somebody to put their guard down. Whether it's, coming at somebody, trying to be extremely friendly, I'm trying to work with you, I'm trying to help you out. That may not be the case in any way, shape, or form. Or trying to get someone's guard down by saying, nothing's going to happen today. You're going to walk right out this door. You have nothing to worry about. You just need to talk to us and help clear the air.
Yeah.
And, that sometimes, many times actually, that all you're end up doing is hurting yourself more often than not.
So, what tends to change when a voluntary conversation becomes more formal or begins to function like it is an interrogation?
I'd say if you could nail down that demarcation, you could probably make a ton of money, because it really is this very fluid thing that occurs, where you know law enforcement tries to say the stuff that we've talked about at the beginning of this in an effort for it not to be an interrogation, but that may not be the case. It depends upon whether or not somebody feels like they're free to go, at any moment, whether they can just get up and walk out the
Hmm.
door, whether or not they've been informed of their Miranda rights, or whether there have been some sort of handcuffs involved or some sort of seizure. Yeah, those are obvious signs of a custodial interrogation, but they're not every sign. And when there's also this difference in the types of questions that are asked. So when it's just a technique to gather information, those are different kinds of questions. I think we all know those information gathering type of questions. Think of it like a reporter, is those who, what, when, where, why type questions. When there's an interrogation involved, or it crosses that line, those questions take on a different life. There's a certainly, I would say, at one end there's an undertone of an accusation, and at the extreme end there's just outright accusations, or we know you were there, or however you might think of it. everybody has their own strategy as far as law enforcement goes, but that's kind of the spectrum.
I was wondering if if it takes on the same thing as a reporter's questions. But how do officers use these questioning techniques during interviews to gather information or shape how events are described?
Yeah, that's an excellent question. I would say that more often than not, law enforcement or detectives, usually it's a detective in something like this, that they're good at their job, come at it from a standpoint or a jumping off point similar to how I would as an attorney. Now, when I cross examine somebody in a court of law, I typically, 99.999% of the time, do not ask a question I don't know the answer to, right? I don't like to be
Hmm.
surprised. There's a version of that law enforcement does. They tend to gather quite a bit of information before they ever sit down and talk to you. Why do they do that? They do that because they're also trying to judge or make a judgment call about your ability to be candid and truthful. And so
Hmm.
it somebody's ability, you may have talked about every single fact that they've already gathered, but then you like leave one very important thing out, or you say that one very important thing didn't happen because you think you're covering yourself. Whereas if you had just been candid about that one fact, but explained why something happened the way that it did, because you weren't candid about that one fact, they may not believe the rest of everything that you've talked about. In fact, I would say that more often than not, we sit down quite a bit with federal law enforcement. And I tell every single client of mine before they sit down with the FBI, the DEA, Homeland Security, whatever agency you can come up with, think of whatever acronym, that just assume that they know everything about the case before you talk, before you open your mouth. And if you think you're going to pull something over on them, you're not. And if you think you're going to inform them of something that they don't already know, you're probably not. And if you do, it sure as you know what better check out, because if it doesn't, they're going to come after you for lying to them. And so, that's, as you can see, as I'm talking more and more about this, interrogations, interviews with law enforcement, whether it's police, federal officials, whatever, is a minefield. When it gets down to it, it is a minefield.
Seems like it for sure. So that brings me to the next question is how does the setting of the conversation, whether it's at someone's home, in a vehicle, or at the police station, how does that affect how the interaction unfolds?
Well, I mean, I would say it affects it how you might think it would.
Hmm.
You know, when you're at your home, you usually feel you're most comfortable, right?
Absolutely.
When you're in an environment like, at a police station, not only is it not your home, so you're out and about in the world, but you're at this place that, it is authoritative in nature. Is a presence. It is, the nucleus for this law enforcement group. So that in and of itself is loaded.
Hmm.
So you can kind of think of it again as this spectrum. And I would say that law enforcement has different tactics for where and when and how they conduct certain interviews and interrogations. So if you want somebody to feel more comfortable and you're just talking to them, whatever else, that might be at somebody's home. And they might rely on body worn camera footage to record that or what have you. But for typically for more serious stuff, they're requesting that you come down and talk to them where they are to kind of put you, off your game a little bit, off your guard, to assert the authority. Because people naturally have an inclination that if they comply, it'll go better for them. And so that psychological trick is kind of played upon. And then all of a sudden you're on the home turf of law enforcement, And on top of it, they're recording everything. They're observing you from the moment you walk in the door. And more often than not, every bit of it is on camera or recorded in some way.
And I imagine people are more nervous and more liable to slip with what events they're relaying to police at that point as well.
But I got to be honest, that has gone both ways in my career, both for the people I've represented and then also for alleged victims in cases where like the recording stayed on while the alleged victim in a case was providing a statement. Law enforcement stepped out, and then all of a sudden you see this person's affect just completely change, where they're accusing somebody of something extremely serious, and then all of a sudden they're just joking around, having a grand old time, doesn't bother them, whatever else. And literally just a minute ago, they were crying their eyes out and everything else. And you're going, how did this person just recount this whole potentially traumatic thing? And then they're just like completely flip the script. And sure, you can make arguments both ways for psychologically why that might be the case. But you can imagine from my standpoint, when you're looking at somebody and their credibility, in that context, how it could certainly affect, how they might be questioned at cross examination, the things you're talking about with the prosecutor and how that person might come across to a jury. I mean, every bit of that kind of gets wrapped up into it.
When someone provides information during one of these conversations, how do inconsistencies or partial statements tend to affect that case later on?
Yeah, so that is something that affects both sides. So again,
Mhm.
I've just been talking a little bit about, when victims, alleged victims, come in and they give statements. If in my world, the more time somebody gives a statement, usually the better, because it is very hard for somebody to give the exact same story each and every single time that they
Mhm.
tell something that occurred. Think about it just when you recount something that happened to you during the day. And you call up your mom
Mhm.
and dad and you tell them, then you call up your brother or sister, you tell them, then you tell your best friend. By the time you've told your best friend, you've told that story the third time, is it the same as the first time you told it? Or is it the same as
Absolutely
how it
not.
happened to you? Not quite.
No, because I usually will add razzle dazzle to it by the time it gets to best friend.
Exactly, right? There's a little bit of extra. So, in my world, when there are discrepancies, inconsistencies, the stories change a little bit, that's opportunity for me to cross-examine and potentially impeach someone. If it's egregious enough, then it comes off like maybe they're making something up. On the other side of that, when my clients potentially give those different statements, or they give a statement that has some inconsistencies, or maybe it's not complete, then that's a similar analysis kind of happens. Instead of necessarily making preparations for cross examination at trial, all of a sudden that person's credibility might be completely wiped out with law enforcement, with a prosecutor, whatever else. You're going and try to relay your client's story to a prosecutor in plea negotiations, and they're coming back at you and saying, "Well, your client said something crazy and wasn't entirely forthcoming, during the time that they sat down with police. Why am I going to believe this now? Or why am I going to believe that they've all of a sudden reformed now?" That conveniently say one thing or the other when it suits them, but what makes it different now? And so that's always something we're trying to be mindful of.
What happens to these conversations after the fact in terms of how they're documented, summarized, or introduced into evidence?
Yeah, so in the state of North Carolina, when a case reaches superior court, everything has to be turned over, unless it's work product of some sort. So we get the recordings of this. We get the summaries by police officers and detectives. It's so important um, to get both of those things, because typically speaking, a detective or a law enforcement official will make a written summary of their interaction with whoever they interviewed. And sometimes they give little details about maybe someone's demeanor or affect that they observe. Because, I mean, as much as you try to look at stuff through video, it isn't always the same as when you're one-on-one, right across from
Mhm.
somebody. But also, too, I can't tell you how many times we've read a report and we watch the video and it's just not the same. And so then
Oh,
all of a sudden, you're going and, you're talking to a DA about, their law enforcement officials' credibility. Like, what did they observe that was so different that we're watching a video?
right.
But it typically these things get recorded, they get turned over to all attorneys, and they do get summarized in these reports. And those all have the possibility of being introduced into evidence if the proper foundations are laid. If all those boxes are ticked, then the
Mhm.
evidence can certainly be admitted. So oftentimes, like my client's statements, for instance, can come in even if they're not testifying, because there's an exception to the rule of evidence that says, statements made by a party opponent can potentially be introduced into evidence, even if they're not, even if they're potentially hearsay. And because of that, it's the state of North Carolina versus somebody. That
Mhm.
person is the party opponent, therefore the hearsay exception can apply.
Wow. Thank you so much, Dylan, for going through what to do if the police say they just want to talk. It sounds like I think we all recognize the importance of being articulate and sharing what we know and all of those things. Thank you for walking us through that process.
Oh, you're welcome. I think, if I could just say one final thing, the the time to get an attorney involved is not after you talked. It is always okay to tell law enforcement, "Hey, pause. I need to go talk to somebody," and they'll be in touch with you. And that I can't state how important that is, because I mean, just all the stuff that I've been over, and how this is a minefield. Talk to somebody before you go talk to law enforcement.
That is excellent advice. Thank you, Dylan.
You're welcome.
Well, that's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.